try to keep it at. On standing, the Planning and Zoning Commission wasn't challenging Hicks's appellant's standing, and I thought Mr. Horner wasn't really going down that standing route, and then Ms. Mowry mentioned it. So let me be very clear. We cited in the record to the January 27 there are numerous references where these people who did testify articulated specific impact to them, including at pages Mr. Baboshka at page 65, Ms. Hicks at page 68 and 70, Mr. Hicks at page 92, Ms. Russo at 112 and 117, Ms. Petsy Rosenblum at 120 and 125. I'm happy to give specifics, but the notion that these people don't have standing is crazy, disingenuous. As to the notion that the Planning and Zoning Commission only has to state the reasons if they're disapproving an application, that's not what Delaware law says. That's not what your remand order says. That's not the advice of their own counsel. They're relying on 6811 at a minimum, at most, I would say. That simply sets the floor, not the ceiling, on what is required. Substantial. We're ships passing in the night, folks. They keep on relying substantial evidence record. Terrapin, get a look at the whole record. Listen to our argument. We're saying that the reasons these people gave for their votes cannot stand. We didn't argue the record is inadequate. That's not our argument. There's an independent basis for the appeal. Because under Delaware law, a public body must state its reasons, not their counsel's, its reasons for their vote. And I submit that's not what happened here. Terrapin is simply not dispositive of controlling here. I do not believe Terrapin involved these facts at all. Terrapin may have talked about motions and records and substantial evidence. That's fine. Terrapin did not involve the situation where the unambiguous record is that the commissioners voted the way they did because their counsel told them how to vote. Law of the case does not apply. It's an arcane principle. It doesn't apply here. And here, remember, you all remain it for further consideration of all evidence facts of the application. Law of the case, there's no evidence, no support for the notion that that principle should apply to this body. Now, should they be able to rely on advice from counsel? Of course. I'm not saying they shouldn't rely on advice from counsel. I'm not saying that he didn't do a good job explaining what the law is. They're misconstruing our argument on purpose. I'm saying that the counsel doesn't get a vote, and counsel can't tell them how to apply the law. A judge doesn't tell a jury how to apply the law. Counsel doesn't tell its client how to apply the law. That's the Planning and Zoning Commission's job. I have no problem with giving legal advice. I have no problem explaining what the law is. But I guarantee you the law of Delaware is not, you can't deny it. That's not Delaware law. Do they have to am I saying that the Planning and Zoning Commission has got to state every single reason 50 ways to Sunday? No, I didn't make that argument. It's a red herring. But they have to give you some basis for you to be able to decide what their independent basis for approval was. Doesn't exist. How do I know if the counsel's advice affected the vote? It's right there. Ms. Stevenson, I was told our counsel says we can't deny it. You can't be any clearer than that. Any other advice would be attorney-client privilege. That's why it's not on the record. I would love to see it, but I respect the attorney-client privilege. Perhaps on remand, you ought to ask what that advice was. That's the reason. Super quick. Again, I said we're not challenging what the law is or what the advice what the law is. It's rather how it was applied. As to the motion being read and how common that is, again, they're missing our argument. We're saying that the motion was not considered in open session. Not that counsel made it. As to the rule of law and property rights, I'm not saying that property owners don't have property rights, but it's a balance. Like everything's a balance, folks. You have to balance the property rights of Shell, and you have to balance the interests of the public and the rule of law as to why a public body needs to state its reasons. not its counsel reasons for its decision. Thank you. I don't know how Your Honor.
We'll
how
have
you
questions. We'll have an opportunity for questions from council later once we get finished.
Very well, thank you.
My objection to the notice requirements is not just, it's strictly not strictly adhered to. My objection is it wasn't even substantively followed out. Like I said, I visited the site several times for a hearing to review the information. There was never any information listed. So they tell you to go to the website, and there's no information there. I had no way to make a basis on my opinion, and they have not supplied when they've put the information there. In my experience, it was never there before the hearing. And that's at the, that's the one I went to, which was the land use listing. Also, as a matter of fact, the majority of online packet, hundreds of pages, is still not on file at the Planning and Zoning Office. They did not contest that either. So the official record doesn't even have hundreds of pages of their testimony. The other thing I want to point out was it was DENREC, not me, that said what the wetlands was. DENREC is the one that said the wetlands were being filled. And that's part of the plus review, and they were required to respond to that. And it's a written response to that. And they did not do that. They totally ignored that part. And lastly, the cases I did for standing, that was their case, and it was on a subdivision. Thank you.
All right. We will.
Or is he going to have a comment?
Yes, I believe Mr. Robertson
I'm sorry,
had some
Mr. Robertson,
time
I
left.
apologize.
I actually don't need any more time, and I thought I used most all of it, so thank you. Yeah, I'll defer it to her 50 seconds.
54 to be exact.
Yes.
No, I don't have anything further to say. Thank you.
Any questions of counsel? Questions of counsel? I don't think so, Judge. I don't hear anybody say anything, so I assume the answer is no.
There being nothing further, Mr. Moore, I believe.
It would be appropriate at this time then for the council to retire in executive session and with a proper motion, Mr. President.
Any motion to go into executive session?